All right, one of the first things that, in my opinion, you should be asking the cop on the witness stand, and probably even on the street as well, are questions about their training for testifying on the witness stand. You could probably ask them on the street, depending on what all you remember for the questions. But I think asking about their questions, asking about their training for testifying on the witness stand should come even before their training at the police academy, which is, it is training that is conducted at the police academy usually, but it seems like one of the most important parts of the trial process is learning their backgrounds on the actual act of testifying at a trial itself, getting familiar with their procedures. And lawyers seem to glaze over it, but when you're pro se, I mean, you're here to learn and pull this out for yourself, especially when you get denied interrogatories or depositions. So you learn this stuff for the first time at your trial, which is what I'm expecting for my trials in Louisiana and Wisconsin. But it also helps educate the jury or the judge if you're forced into a bench trial. You got to beg for jury trials. You're forced into bench trials. But I want to establish the background of these cops and get that right on the record for everybody to see. And I've learned a little bit about the police backgrounds on testifying in court in Wisconsin. I know that they got 8 hours of training, but what's involved in that 8 hours? That's a pretty long period of time for training. So they likely go through a lot, and this is an increase from 2005, I believe, to 2020. 2020 definitely, I know that it's 8 hours, but what was it in 2005? It seems like it probably was less. But what you want to do with these questions is expose that the officers are trained to control their testimony and avoid self-incrimination rather than just tell the full truth. You show that their training influences their answers, making them appear more credible than they actually are. If you think about that, I mean, it's not just about them observing on the scene. They're tailoring their answers for the courtroom to make themselves look better. It's not just, facts on paper. It's more than that. There's ways that they conduct themselves, the ways they answer that they want to use to influence a guilty verdict for the defendant. Highlight testimony tactics such as avoiding direct answers, deflecting responsibility, and relying on vague phrases. I want to highlight that. Okay, avoiding direct answers. That's a popular one with the courts. Make it clear to the judge that this officer's testimony is shaped by training, not necessarily full transparency. Okay, and then I go into questions here. I'm establishing the officer's training in the courtroom. Officer Aide, you have received training on how to testify in courts, correct? Okay. In fact, law enforcement officers are specifically trained on how to be effective witnesses, correct? You were taught that testifying is a skill that can be practiced and improved, correct? Part of that training includes learning how to maintain control over your testimony, correct? I think that's a good question. That's where we really get into the heart of the process of how they answer. How the cop maintains control over their testimony. They don't just do it when they arrest you, maintain control. They want to maintain control at the trial, your trial. Your training includes how to avoid saying something that could be used against you, correct? You participated in mock trials as part of your training, correct? You've been trained on how to handle tough cross-examinations, correct? And part of that training includes strategies for avoiding verbal traps from defense attorneys or pro se defendants, correct? One of those strategies is keeping your answers short and direct to avoid revealing too much information, correct? You were specifically trained to only answer what you know rather than what you think or assume, correct? And I had Officer Davis do that to me, asking me if I'm asking his personal opinion or his professional opinion. My answer could have been better for that, and I could have been like, I'm asking you what you know, not what you think. You know, this personal, your personal observations versus your private observations. That's him controlling it. You take control back by saying, I'm asking you what you know rather than what you think or assume. All right, training on avoiding self-incrimination. During your testimony training, you were taught to stick closely to your report, correct? In fact, you were trained to rely on your report to avoid contradictions, correct? If something is not in your report, you are trained to say you don't recall, correct? See, and that's establishing, this is what we can expect from this officer. I'm making it open. I'm being very open with the judge, the jury, that he's trained to say he don't recall. This isn't some spontaneous, oh, I don't recall situation. He's trained to do that, to say I don't recall. They're trained all the way through. Officers are specifically trained to avoid guessing or speculating, correct? If an answer could expose an error in your actions, you were trained to avoid speculation, correct? So, I mean, right there, you shouldn't have to be sitting on guard waiting for the cop to speculate. Or if you do, as the prosecutor's asking him questions, the cop is less likely to speculate on answers than a regular witness, because that's a part of their training. And you were trained that if you don't recall something, it's better to say, I don't remember, than to try to guess, correct? So, I can't say if you were to guess. They're trained not to guess and stick with I don't remember. So that you don't want to push this try to guess line of question. Eventually, you'll get objected to by the prosecutor, maybe even the judge. You were trained to pause before answering difficult questions, to give yourself time to think, correct? So there could be uncomfortable moments where they could be staring at you and just, it's their way of thinking of the best answer. You were trained that if a defense attorney asked a yes or no question that could box you in, you should try to reframe the question, correct? So I had that happen with Officer Davis at trial number 1 in Natchitoches. He just asked me to reframe the question. Can you rephrase the question? He was just practicing his training, but I was clueless at the time. Now I have a better understanding. See, I was clueless because I couldn't get training records. I couldn't get the police policies. So they're practicing their training. It's coming from somewhere, but they're not allowing the public to see where it's coming from. These tactics. And if necessary, you were taught to ask for the question to be repeated or clarified, correct? Training on reinforcing credibility. Part of your courtroom testimony training includes how to appear credible, correct? You were trained to project confidence when testifying, correct? You were trained to maintain eye contact with the judge when answering questions, correct? That's interesting. I don't know why ChatGPT would say that. Say that you were trained to maintain eye contact with the judge? Because it's like, I would think that maybe he would want to maintain eye contact with me as the defendant. But it's not saying that. It's saying you'll make eye contact with the judge. Maybe ChatGPT's got it wrong. You were taught that your tone of voice, body language, and demeanor all affect how credible you appear, correct? And part of your training is to avoid appearing defensive, correct? You were trained that if an attorney suggests you did something wrong, it's important to remain calm and composed, correct? You were trained that appearing offended by certain accusations can make misconduct seem less believable, correct? So they're trained to appear offended by certain accusations, okay? So acting offended, that is a trained response. Training on handling cross-examination. You were trained to avoid answering yes or no questions when they might make you look bad, correct? Instead, you were trained to rephrase questions in a way that keeps control of the narrative, correct? You were trained that if an attorney asks a tough question, you should take your time before responding, correct? And if you were trained that if an attorney tries to push you into an answer, you should push back by asking them to clarify, correct? You were taught to avoid admitting mistakes outright and instead minimize them as minor lapses in memory, correct? When pressed about potential mistakes in your actions, you were trained to say you were just following orders or policy, correct? So be prepared for that when you want to call them out on misconduct. They're just following orders or just following policy. But in my Louisiana situation, they're not letting me see the policies, see the important parts of the policies. So when they want to say I'm just following orders or policies, I don't have anything to refer to. And the judge even says I'm not allowed to see policies. It's crazy. Training on using police-favored language in court. Officers are trained to use certain key phrases to justify their actions in court, correct? For example, you were trained to use phrases like, based on my training and experience, to justify decisions, correct? You were trained to use terms like furtive movements or unusual behavior to broadly justify suspicion, correct? You were trained that if you say, I feared for my safety, it helps justify your actions, correct? You were trained that referring to something as standard procedure makes it sound more reasonable, correct? Okay, here's the next section. Training on working with the prosecution. Because that's important. Before trial, did you meet with the prosecutor to go over your testimony? You were trained that prosecutors may review key points with you before trial, correct? You were trained that watching other officers testify before you can help you stay consistent, correct? And they should not be watching other officers testify at all. They should be separated. All right, so then the key takeaways for the judge. Cops are trained to give testimony that sounds credible even when it's not entirely transparent. This might be the ending arguments. They're trained to avoid revealing weaknesses, downplay mistakes, and reframe tough questions. They work with prosecutors to align their testimony and avoid self-incrimination. They use carefully crafted language to justify actions that might not actually be legal or reasonable. Use the officer's own training against them. If they admit to testimony training, argue that their entire narrative is rehearsed, not necessarily truthful. Point out inconsistencies. Show where their testimony contradicts their reports or previous statements. Expose courtroom tactics. If the officer avoids answering or reframes questions, point it out to the judge to show they are being evasive. That's what I should have done with Officer Davis. When he asked me to rephrase, I just jumped in and started rephrasing, whereas I could have said that he's being evasive. And then even when the prosecutor objects, I could be like, he's just objecting to be evasive. Challenge credibility. Argue that the officer's testimony is shaped by training rather than just honest recollection of events. Okay, so that's it. That's the presentation, and that's all I got to say about it.